Okay, so we are working on problem 3, and it is now, we're going to dive into, as I mentioned the other day, the area of this particular unit where we get a whole lot of law. Okay, so we're back into the federal statutes and so forth. And the other, the sort of subsequent topics that we're going to be studying definitely involve some law, but this is like, heavy statutory, regulatory type of stuff. Okay, so the topic today is RCRA, CERCLA, and brownfields. Okay. RCRA is the Resource Conservation Recovery Act. And one of the things I'll just mention from the outset here is that both of these statutes were pretty bread and butter in my environmental practice in Texas when I practiced environmental law. And I continue to deal with them in various roles and government task force and nonprofit organizations and that kind of thing. But this is definitely, these two statutes are ones where I gave a lot of clients a lot of advice and guidance about how to navigate them and so forth. So important area of law to master if you're going to do any kind of environmental law. So RCRA is a statute that is about management of waste, and it is really a cradle-to-grave regulation of waste. That's what's, that's what everybody calls it, cradle to grave, which basically means from its generation to its disposal, all the way through. So this is the first federal statute to ever do an entire life cycle approach to regulation. The statute has 4 primary goals, which are to determine the classes of waste coming under RCRA authority, to create and implement a tracking system for hazardous waste from its creation to its disposal, again, that life cycle approach, to establish handling standards for waste from generation to disposal, and to provide mandatory authority for cleanup of polluted treatment, storage, and disposal facilities. Now, the statute does more than that, okay? So do not limit yourself in your understanding of RCRA to just these 4, but these are 4 sort of primary things that were on the mind of Congress when it created RCRA. One of the things about RCRA is it looks like it's extremely broad, okay? From the very outset, it looks like it potentially covers pretty much just all waste of any sort. And then what you find is that while there are aspects of the statute that do cover non-hazardous waste, okay, and also some aspects of the statute that cover liquid waste, the primary focus, or the where a lot of the attention is in what's called subtitle C, which is solid hazardous waste. Okay, so that solid hazardous waste gets a whole lot more attention. Okay, so let's start with RCRA regulates solid waste. Okay, so starting point of the statute is regulate solid waste. And like you might expect by now in law school, when we say solid waste, that's not what we mean in the slightest. It is not limited to solid. It is basically solid waste is defined by statute, right? You let a bunch of lawyers and members of Congress get together and they define solid waste to include garbage, liquid waste, solid material, other discarded material, contained gases, leachate, okay, all sorts of things, okay? So it can be liquid, it can be gaseous, okay? So even though the statute on its face says solid waste, the definition is so broad that it includes other things, okay? And leachate, by the way, there's some attention to it in the book, but it's basically where you have water that is somehow percolating through or flowing through waste. So think about what's happening at this very moment with all that rain outside that is falling on landfills, okay? And those of you who did not recycle your batteries, but instead threw them in the trash, okay, right? And so forth. And those are sitting in the landfill somewhere, and that cadmium and nickel and so forth that's in the batteries is leaching out of those decomposing batteries into the groundwater, right? And so leachate is where the water percolates through and it picks up various contaminants along the way. Okay? And so all of that is regulated. RCRA also regulates underground storage tanks of petroleum and other hazardous liquids, such as solvents and pesticides. Okay? So, gas stations, these big tank farms where you have natural gas tanks or oil, gasoline, that's going to be for getting picked up by the tanker trucks and taken around to the various gas stations. All of that ends up being subject to RCRA regulation. We will see later that oil and natural gas are expressly excluded from CERCLA liability. Okay, so that's going to be one of the things you might start confusing in your mind. Okay, so oil and gas is, when it's in underground storage tanks, subject to RCRA regulation, but when we're talking about liability for contamination, petroleum products are largely excluded from CERCLA liability. Okay, so just point that out up front, so you have to distinguish between the two. So the idea here behind the provisions regarding underground storage tanks is to avoid groundwater pollution, and the statute expressly includes creation of a fund to address leaking underground storage tanks. Leaking underground storage tanks, which are called LUSs. And when this came about, when this particular provision got enacted, you can imagine that lawyers who are nerdy and especially if they do environmental law, it's all very technical. You can imagine the joy they had in having CLE programs about lust. Okay, right? I mean, so it tells you that they have very sad lives. But nonetheless, that if you go out there, people refer to lust. That's what it's about: leaking underground storage tanks. And it's a problem. I mean, it's a serious problem. Okay, there are many, many older gas stations out there that have leaking underground storage tanks. Right? Those tanks are very old. They've deteriorated over time. They did not use the technology that's available now. Right? So now we use secondary and tertiary containment procedures for underground storage tanks, but older facilities did not, and so forth. Next issue we want to ask, is the waste in question, is it a part of the waste stream or not? So this has become the subject of a fair amount of litigation. You saw several cases that were discussed in the reading about the exemption for recycling. Okay, so basically the idea is the statute wants to encourage the recycling of waste, the reuse of waste, okay, but it does so only if there is some ongoing process for that, and that it is being put to or made available for immediate reuse. Okay, so what does that mean? It means that this is really about industrial processes, Okay, so you've got an industry and they've got waste coming off of their industrial processes, but they can reuse that waste. They can put that chemical back in the system. Okay, one of the issues that used to come up was, well, you know, when they have that coming off of their system and they're storing it in some storage drum, you know, some big storage drum and so forth until they can, you know, put it back in the system. Is that subject to RCRA? And the answer is no. The answer to that is no. But if, on the other hand, what you're talking about is the stuff that you put out at the curb in what's called recycling, okay, that is not considered recycling for the purposes of RCRA coverage, or you know, the what's subject to RCRA, because you basically are putting it in the waste stream, right? Okay, so it's not like, okay, so just think about this, like you get a paper bag from the store, from the grocery store, and if you put it in your cabinet to reuse for taking your lunch in, you know, this week or something like that, or next week, okay, that has not entered the waste stream. If, on the other hand, you put it in the municipal recycling bin, it has entered the waste stream and it is subject to RCRA. Now, RCRA doesn't care about your paper bag for the most part, okay, before we get to that, okay? But if, on the other hand, instead of your paper bag, it's some sort of hazardous substance, then again, the key is your exemption only applies if it's an ongoing process and it's available for immediate reuse. And immediate does not mean in the next 60 seconds, it does not mean in the next 90 seconds, but it also means you're not just storing it for some lengthy or indefinite period. Then the next issue is the waste in question exempted by statute? And as your book points out, this is one of the kind of weird things about RCRA, is that here it's supposed to regulate all waste, and then they have these big, huge exemptions. So point source discharges into waters are not subject to RCRA regulation. This is actually one of the key legal aspects as to what's going on with the regulation or non-regulation of coal ash waste. Okay, so if you just read the news, you know, you get the impression that that neither the federal government nor the courts want coal ash waste to be regulated. What the Sixth Circuit and Fourth Circuit have said, though, is that the lawsuits that were brought before them had to do with regulation of coal ash waste that ended up in waterways. Okay, so one of the big ones is Kentucky Waterways Alliance. Okay, so right here in Kentucky, it's Kentucky Waterways Alliance case. And what the court said is that Congress made it very clear that it has an entirely separate regulatory regime for point source discharges under the Clean Water Act and regulation of solid waste under RCRA. And so they said coal ash waste is subject to RCRA, and then there's also there's a special coal combustion rule that the EPA adopted, and they sort of said, hey, that's how you're supposed to regulate coal ash, not under the Clean Water Act. Well, the reverse is true. Okay, things that are regulated under the Clean Water Act are not regulated under RCRA. Okay, right. So if you've got a industrial facility and it has an NPDES permit to put a bunch of pollutants into the waterway, it's subject to EPA regulation through the state, but under its NPDES permit under the Clean Water Act, not under RCRA. Domestic sewage, also not subject to RCRA. That also, as you know, is subject to the Clean Water Act. Mining waste, nuclear waste, those sorts of things. All right. Next, when we talk about RCRA regulation, again, we're talking about solid waste, but one of the big questions is it hazardous waste? Okay? Is it hazardous waste? If it's hazardous waste, it is subject to Subtitle C. The bottom line is if you represent any client that might have some sort of waste and they're asking you for some sort of advice or analysis or help with their legal problems, your client desperately does not want to be subject to Subtitle C regulation. It's significantly onerous. And so they would much prefer to either be exempt altogether, or if not exempt, then subject to Subtitle D, which is non-hazardous solid waste. So that's an issue. Something I went through this a lot, this basic analysis a lot in practice, kind of working my clients through this. So is it a hazardous waste? There are two categories. One is the category of listed hazardous waste. These are waste that the EPA has identified as hazardous pursuant to notice and comment rulemaking and have been published first in the Federal Register and then codified in the Code of Federal Regulations, CFR, right? So you can find out exactly which ones these are by going to the CFR, right? And that's how it's done. So these are ones where the EPA has determined on the basis of the science that these are hazardous substances. And there are two additional rules that go with this, okay? So that it's not only the hazardous substances, but also hazardous substances that are mixed with non-hazardous substances. Hazardous substances that are mixed with non-hazardous substances. That is the mixture rule. Okay, so that is going to include, for example, leachate. Okay, that's where we talked about leachate is a problem, right? Because it's got rainwater, but now it mixes with the hazardous substance and goes into the groundwater. It's a problem. It also includes what we call derivatives or things that are derived from a hazardous substance. That's called the derived from rule. So if it was hazardous and you extract things from it and so forth, it remains considered hazardous even if it doesn't really have any hazardous characteristics. It is, even if it's not physically or scientifically or chemically not hazardous, it is legally hazardous. That makes sense? Okay, right? Well, your book, your reading for today points out you get a lot of ridiculous outcomes from how these rules operate, right? You have these big, huge exemptions. Nuclear waste is not subject to RCRA, but some scientifically non-hazardous derivative of a hazardous waste is, right? Does that make right? So that's part of where they're coming from. That's what they mean when they say you get these outcomes that are sort of a little illogical, okay? But the thing is that there are reasons for these rules, in part because you just need some bright line rules, in part because it is a system that requires tracking, right? And so it's hard to go in and out of the tracking, right? And so forth. And so, but also in part, this is the scheme that Congress has come up with. The second kind of category of hazardous waste are what are called characteristic waste. These are wastes that even if they do not appear on a list in the Code of Federal Regulations, if they have certain hazardous characteristics determined by flammability, corrosiveness, reactivity, and toxicity. And I cannot tell you how many times in practice I went through these four types of characteristics, these four categories of characteristics with clients. And the client flips out because they say, well, why can't you tell me whether whatever stuff, bad stuff I'm producing falls in this category? And the answer is because you actually have to have it tested to see whether it has these flammable characteristics, these corrosive characteristics, these reactive characteristics, and these toxic characteristics, okay? So there is a rule, it's a law-based rule, but the actual determination about whether a substance falls into that category or not is a purely scientific, technical determination. You have to do actual tests, okay? So you know, unless you happen to have a PhD in chemistry or something, generally, I hope you are not telling your client, yes, this is a characteristic waste. Instead, what I hope you're telling them is, okay, these are the tests that have to be applied. This is what the standard is. You need to send it to the appropriate lab to determine that, okay? And that's exactly how it works. I guess this stuff gets tested in the lab, okay? But the good news for your client is, unlike listed hazardous waste, if the substance at some point loses its hazardous characteristic, it is no longer hazardous. It gets to drop out of the system. Okay? So that is it's probably not much of a consolation to your client, but it's one. And I know I have problem number 3. That's not the kind of client we're talking about. But just as you think about practicing law, that's one of the issues. If a substance is not a listed hazardous waste or a characteristic hazardous waste, but it nonetheless is a solid waste, the less onerous Subtitle D regulation applies. Municipal waste, which we tend to think of as garbage, is treated under the statute expressly as non-hazardous, and that's true even if there are small amounts of hazardous substances in it. Okay? So, like I mentioned before, people throw their batteries in the trash. They're not supposed to. It's bad, but nonetheless, Congress has decided that it is not what they want to do to try to regulate every landfill of every city in the United States as if it's a hazardous waste site. Okay, that's not the issue. Now, having said that, okay, that is only under RCRA. If there's enough hazardous waste in a landfill that creates contamination under CERCLA, then the municipality may very well, actually will be, liable under CERCLA for the cleanup. Okay, so that's a different, right? So, right, which is just differentiating these two statutes in our mind. There's RCRA and there's CERCLA. RCRA is a regulatory statute. CERCLA is a liability statute. And we're going to see when we get to CERCLA that it's much more expansive, includes more things. Okay? So, but basically, the local landfill is regulated under Subtitle D, but it is a less onerous amount of regulation. Okay? All right? So, who gets regulated? 3 categories: generators of waste, transporters of waste, and TSDs, treatment, storage, and disposal facilities. Now, generators, transporters, and TSDs. The book points out that the most significant amount of regulation, the most responsibilities, are on TSD facilities because they're the ones that there ends up being contamination and leakage and bad stuff that happens. Generators are the second most regulated because, of course, they're generating the stuff. Transporters are somewhat regulated, but they are mostly regulated in terms of how they handle it, how they transport it, labeling, following the hazmat routes, etc. Right? And you see the signage, right? All those hazmat stuff. And there's certain tunnels you can't go in if you're if you're carrying hazardous substances, right? So, right? I mean, so I think weren't they doing that with all the I-64 construction, that you couldn't go that way, right, and so forth. So that's all subject to federal regulation under RCRA. So we start with generators having to classify the waste when it's created. Right? So we're talking about cradle to grave. The waste gets born, okay, it has to get named, it has to get classified, right? Birth certificate, right? So, it has to be labeled and tracked. That means there's a manifest system, okay? And I mean, really, this is a very in-depth, highly monitored, highly recorded system. So presumably, the regulators for sure, and actually many people, can determine exactly what hazardous waste is, how much of it there is, where it is, at any time, all the way from the point at which it's generated, all the way through the point at which it's disposed of, and while it is disposed. So, I guess until it totally disappears from the environment, we have a way of tracking it through the manifest system. And there are record-keeping requirements. Now, does that mean that nobody ever fails to do this? No, of course not. There are people who do not do what RCRA requires. Okay? At that point, either your expertise needs to be the intersection of environmental law and criminal law, or you need to find a colleague who does criminal law, because if there are generators, transporters, or TSD facilities that are not doing the tracking and the record keeping and using the manifest system, the EPA is most unforgiving about that, okay? So, because the idea is we want to know where it all is, okay? And so forth. So that's part of the system. Then there are a variety of standards, regulatory standards, that apply to the storage of waste. And they're relatively technical. I don't think that especially important for us. The general gist is, of course, the idea is to require anybody who's storing hazardous waste to store it safely, store it in a way that is not going to lead to leakage and contamination and exposure of humans or the environment to that waste. I mentioned the transportation requirements. There are a variety of requirements related to transporting waste. Again, labeling not only the waste, but also labeling the transportation vehicle. So again, right, you see the hazmat, kind of signage on vehicles and so forth, and how and so on and so forth. Again, think about this manifest system and this record keeping, right? You've got bad stuff on a truck moving through your community, okay? One of the things is first responders need to know exactly that, right? They need to be able to tell instantly what exactly it is, where it is, on what truck it is, what, et cetera, right? Does everybody see that, right? I mean, that's exactly part of what this is. Now, there's a whole other statute that we're not getting into too much called the Emergency Planning and Community Right to Know Act. It's EPCRA, and it deals with sort of sharing information with the public and some emergency response kinds of things, but they sort of intersect. The regulatory standards impose a variety of standards that are aimed at clean operations of these facilities, but basically, again, non-contamination, anti-contamination, and to make sure that when the facilities are done operating, the closures or shutdowns are clean, right? That we don't have any contamination. If there is any, it gets cleaned up, and so forth. And there is supposed to be monitoring for pollution and contamination. And finally, all this is implemented through a permit system. The permits are primarily for TSD facilities. Okay, so TSD facilities are heavily permitted. So one of the things that is important from an environmental justice perspective is you can find through the EPA's database exactly where all the TSD facilities in your community are. Right? They're permitted, their location is identified, and there's something called, there's an EJ mapping device where it was actually, I don't know, I forget how old it is, but it's been, I don't know, the last decade or so, that basically you can, it's a mapping system where you can take, say for example, low-income characteristics, or racial and ethnic characteristics of the population, TSD facilities, and so on and so forth, and layer them and create maps that show where these are. And as you might expect, there are disproportionately higher number of TSD facilities in low-income communities of color, of census tracts that have higher percentages of low-income people, higher percentages of people of racial and ethnic minorities than in the other census tracts. Okay, so that is pretty clear-cut, and we're going to get a little bit more into that when we talk about environmental justice. But part of how we're able to assess that and monitor that has to do with the RCRA and the way that it is very information gathering, information monitoring intensive. Okay. So some more stuff on how it works. So I've already talked quite a bit about the cradle to grave tracking system. That's huge. That's very important. The law also has embedded in it some directives aimed at reducing waste, reusing waste, recycling waste, and then only then should it go to the landfill. Okay. Having said that, this particular aspect of the statute is less effective. Okay, so less effective. The reduce, reuse, recycle, and then landfill part of the statute is less effective. The statute uses permitting and permit systems to regulate the activities and behavior of the regulated community, of the waste generators, the waste transporters, and the waste storage and disposal facilities. There is a ban on hazardous waste in landfills. That's called the land disposal ban, and that is an important piece of this because that was not always true, right? Before RCRA came along, a lot of hazardous waste got just dumped in landfills. And so you have your local, municipal garbage, and you have, big bad, chemicals and stuff being dumped in the same landfills, and that was not good. So that was a key development. We do know, however, that landfills do have some hazardous waste, and that does not take them out of Subtitle D. It leaves them there. But part of the Subtitle D requirements, though, is that the landfill operators have to follow certain, incorporate certain pre-treatment standards to prevent groundwater contamination. Okay, and this is called the no migration rule. Okay, so think about this. Right, you've got all that stuff in the landfill, all that garbage, and so forth. And the question is, what's going to be done to prevent, when again, like this rain that's going on now, to prevent that from ending up in the groundwater. Okay, so then there's a variety of things. There's various kinds of liners Okay, so there's clay liners, there's plastic liners, you can actually have concrete liners. There are various kinds of things that have to be used in landfills to try to prevent groundwater contamination, no migration. The lust funds are also important because, think about the leaking underground storage tanks. What are we talking about? We're talking about gas station. We're talking about a number of things. It could be, for example, pesticides in some places that had a bunch of underground storage tanks with pesticide, big amounts of pesticides stored there. But just think about the typical gas station that closed down 30 years ago. Okay, right? Those tanks are old. They're going to be leaking, and who knows who owns that gas station? They may no longer be in business. They may no longer have any funds available to deal with it. And so what's happening? Local groundwater supplies are being adversely affected, and there's really nobody to do anything about it. In addition, if it's petroleum, it's exempt from CERCLA liability. So there's nobody put on the hook under Superfund law for cleaning it up. So part of the idea is these lust funds are meant to address this so that you don't end up, so there are federal funds available to get in there in a kind of emergency situation and stop the leaking from happening and get all that cleaned up. There are state plans that are, so basically states have to have plans for how landfills are managed and operated, and they can adopt regulations if the regulations are consistent with federal regulation under RCRA. And so the book refers to this as cooperative federalism and so forth. It's a little more complicated than that because because while theoretically states can regulate more stringently than RCRA, the consistency requirement has at times been interpreted to basically invalidate state regulations that were more restrictive under the theory that their more onerous regulations are not consistent with federal standards. So it's, so yes, there's some cooperative federalism going on there, but it's a tricky act if you are a state government or a local government and you're trying to regulate waste sites. And we're going to talk about preemption in just a moment. Okay, so another mechanism involves corrective actions that require the cleanup of contamination. And then, so we're talking about that in just a moment, and I'll just list it here. And then finally, one of the things that's sort of a problem with RCRA, one of the limitations is that it doesn't really facilitate or incentivize the production of less waste. There's no real strong mechanism there that really means we're going to produce less waste, and so that's a challenge. Okay, so there are some EJ issues with RCRA, and several EJ issues that are, first of all, highly relevant to problem number 3, and then also raise some interesting issues. Okay, so first of all, there are questions about citing these facilities. Any of the facilities that are subject to RCRA regulation. So obviously, even though landfills get less regulation, they get some regulation under Subtitle D of RCRA, and they are, again, disproportionately cited in low-income communities of color. Well, I'll just start referring to them as EJ communities. Okay? TSD facilities for hazardous waste, I've already mentioned, they are disproportionately located in EJ communities. One of the other big issues that has come up in the environmental justice movement has to do specifically with hazardous waste incinerators, where there's an intersection between RCRA and the Clean Air Act. Okay, so while there are entirely separate regimes between RCRA and the Clean Water Act, and so forth, they're actually, when it comes to hazardous waste incinerators, you have both RCRA and the Clean Air Act that end up being applicable. But even things like the hazmat traffic routes, okay? So a lot of EJ communities are very concerned about what is being transported through their neighborhoods. So think about, if you've got, instead of the hazardous materials going right through the middle of downtown, they're going all the way around the Watterson, right? They're going right through West Louisville on their way to I-64, right? Or from I-64, right? Okay, so that's a concern in those neighborhoods. Also, very often, these neighborhoods have or are located near rail transportation, right? Okay, how many train accidents have you seen on the news in the past 5-10 years around here, if you happen to be around here, and if you're not, you've probably seen them in your own home communities, right? But where there's like something really bad that it is now contaminating the environment, and they have all these emergency response teams and hazmat crews and so forth, right? So right down in Bullitt County a few years ago, it was like really bad looking stuff, and they had everything blocked off and you couldn't drive anywhere and so on and so forth, right? Because you got hazardous materials being transported on the trains. And those oftentimes in urban areas, they're more likely to go through or near the lower income communities. So when it comes to the siting, the decision about whether that is going to be allowed in a particular community, one of the challenges is, yes, there are federal standards, and yes, they are aimed to prevent contamination and to protect the public health and safety, and there are also public participation opportunities and so forth. The participation is not really what we might call engagement or inclusion, right? It's a very sort of formal process. People do get to have to have their say, but it's not really a cooperation between the regulators, the facility proponents, and the neighborhood where it's going to be. In addition, there are a whole variety of state and local regulations over the years that have been deemed to be preempted by the federal standards. Okay? And so those of you who really are very excited to know that there is some application of the Dormant Commerce Clause, you're like, oh God, not that, right? Okay, not the Dormant Commerce Clause, but yes, it rears its ugly head right here in environmental law, so it's an issue, right? I mean, basically, to some degree, with some exceptions in the statute for these state plans and so forth, to some degree, courts are more likely to say RCRA occupies the field of citing these waste facilities. And so state and local regulations that might aim to protect neighborhoods or make it difficult or impossible to site these facilities in certain places have been deemed by the court to have been preempted. So that's a problem. And then the question is, are the decision makers about these permits considering environmental justice at all? Okay? What we're going to discover next week is theoretically they're supposed to, under a federal executive order and a presidential order, but the reality is generally they're not. Right? They're generally not looking at things like, is a particular neighborhood overburdened already? Is there a disproportionate impact on a particular neighborhood? Does this neighborhood have any special vulnerabilities in terms of human health or exposure or risk? And I'm not saying that those aren't ever considered, but generally there are not very many good mechanisms for requiring or forcing the EPA officials that are doing this to consider it. Because generally what they're looking at is, here's a checklist of all the things that have to be done in order to get your RCRA permit, and they're just kind of going through that, looking at whether it meets that. The other thing that's going on, of course, is there's this assumption that these things have to be sited somewhere, right? We all need landfills. We all need, we all use things in our world that that generate hazardous waste in some way or another, and the question is where where are we going to put them? And as you can imagine, that higher income communities that are more white, have more political power, more political clout to keep them out of their communities, right? I mean, I'm out in the East End, and there's not that many TSD facilities out there. There's not, right? Okay, so that's just the reality of how this has played out in a very unequal and environmentally unjust way. So that's a real limitation to RCRA, is what I'm saying. It's a limitation to RCRA. Another issue has to do with enforcement issues, under-enforcement, disparities in enforcement. So the EPA has authority to enforce its permits under sections 3005 to 3009 of the statute. Okay? And so this is a useful set of enforcement tools about the permits, but it often is very narrowly tailored to whether a permit condition has been violated or not, right? Okay, so it all depends on what's in the permit and so forth. What's interesting about RCRA is there's an entirely different set of sections, and what we care about at this moment is section 7003, which is the corrective orders section where the EPA has the authority to seek injunctions against anybody that is going to potentially cause contamination that would impose an imminent and substantial endangerment to the health or to human health or the environment. Okay, so that's the imminent and substantial endangerment section or clause, and so this gives the EPA actually pretty broad authority that even if something hasn't been regulated, even if there's no permit condition available, they can take very proactive action and say, hey, for example, your drums are deteriorating, and you need to take immediate action to contain the waste and replace the drums. And if you don't do it, we're going to go seek a court injunction forcing you to do it right now. Okay, and so it's a very powerful tool. And so one of the things about that is different between 3005 and to 9 and 7003 is with 7003 you can not only prevent danger prospectively, but you can also impose retroactive liability for correcting the harm. The EPA can. Okay, so that's one of the advantages. Relevant to environmental justice groups like the one that we're representing is Section 7002. Okay, Section 7002, citizen suit provision. So this is also a provision that allows any citizen group, so that includes any environmental group, includes any environmental justice group, to bring a lawsuit seeking an injunction against any potential contributor of contamination to the environment, of contamination of hazardous waste environment, to prevent imminent and substantial endangerment to human health and the environment. Okay? So it's the same standard, the imminent and substantial endangerment standard, and it basically says, citizen groups, environmental groups can bring this, and mere risk of harm is enough. There are some significant limitations. They're not on the slide, but we'll add them to your notes. Okay, so one big limitation, I just ran out of the room, I'm sorry. But one big limitation is that the environmental group cannot bring the suit if there is an ongoing federal agency action. If there's an ongoing federal agency action, usually we're talking about the EPA. Generally, actually, if a state government is taking action, they also are precluded from bringing the suit. So federal or state government action to prevent the contamination, then the environmental group cannot bring the suit, okay? Because the theory behind this is we need to give the regulatory agencies the room, time to address this. They're our first preference, and only if they don't act, only then will the environmental group bring the suit. Secondly, is that before the environmental group brings the suit, there is a 90-day notice rule. 90-day notice rule. They have to give the prospective defendant, whoever the cause or likely generator of this hazardous contamination, and the relevant federal agencies and federal and state agencies notice that they intend to bring the suit. Because again, the idea here is instead of going to court, we would rather that the prospective polluter take action to prevent their pollution or stop their pollution, or that the federal or state agency will take action against them, rather than having this sort of play out in court. Okay, so those are a couple of significant limitations. And another limitation is that while the environmental group can get an injunction that requires the polluter to spend money to correct the harm, if the environmental group or somebody else, local government or whatever, has spent the money themselves to correct the harm, they cannot get restitution. Okay, so it's only injunctive relief, not restitutionary relief. Okay, right? So that is also relevant. But another key point that's not on this, but it fits with what we've said before about the Clean Water Act, the successful environmental group can get attorney's fees. Okay, so this again is favored by environmental groups because they can get attorney's fees if they're successful. But as you might imagine, if the polluter doesn't want to pay attorney's fees, and they don't want this sort of angry environmental group going after them, what are they going to do? They're either going to come into compliance themselves, or what are they going to do? They're going to ask the federal government to take action against them within the 90 days, right? Because A, they think that the federal government is easier to negotiate with than the upset local group, right? And B, they won't have to pay attorney's fees, right? Does everybody see those litigation strategies on that? So what does that mean? It means that there are some potential tools that an environmental justice group like the one you're representing has, but there are also some significant limitations to the use of those tools, right? And if the EPA is under enforcing, the group has some some opportunities to try to enforce, but they also have some limits to them. All right, so now let's turn to CERCLA, the Comprehensive Environmental Response Compensation and Liability Act, which is a Superfund law. And the basic concept is you have strict joint and several liability for the cost of cleaning up, including remediating. Remediating is not the only type of cleaning up, but it's the most common type. Hazardous substance contamination for any contributor to the contamination and any owner or operator of the site of contamination, subject to certain exceptions. Okay, so the whole idea here is to generate funding for contaminated site cleanups. So when does CERCLA apply? So first of all, it applies to any release or substantial threat of release into the environment. And just look at page 255 for the definition. It's like the whole laundry list. It is the authors said it looked like some intern on Capitol Hill just got out the thesaurus and went through everything that could possibly write. That's a little snarky, but it's a very broad list. Okay, and it applies to any hazardous substance, which is also extremely broad. That includes any substance that is designated as hazardous under any of a whole number of federal pollution statutes. Okay? So not just the RCRA list. Okay? Not just the RCRA list. In addition, the EPA can list things that count as hazardous substance, and furthermore, the EPA can just decide on a case-by-case basis, make a determination that a particular substance poses risk of imminent and substantial endangerment to public health and the environment. Okay, so much broader, right? RCRA has a much narrower, it has a pretty broad definition, but this is even broader definition of what counts as a hazardous substance. By the way, it does not have to be a waste. Notice we're talking about hazardous substance, not hazardous waste. Okay, it doesn't have to be waste. It's way beyond RCRA. However, petroleum and natural gas is expressly exempt. I think I couldn't decide whether I was going to say exempted or exempt, and so instead is French, exempt. So anyway, all right. And then third, it applies to any facility. Okay, that is also extremely broad. It's basically any place or structure, site, building, pipe, conduit, whatever. Basically, if it's got a geographic existence, it's a facility. There is one basic command and control regulatory requirement in CERCLA, which is any person has a duty to notify the EPA of any known release of a reportable quantity of hazardous substance. Okay? So that is a regulatory requirement. It applies to any person. If you know of a release of a reportable quantity of hazardous waste, you are to report that to the EPA. We are going to start talking about sites because we are talking about what we're cleaning up. So sites are usually, a particular facility, maybe it's a set of facilities, but we're talking about a particular place where we have contamination of hazardous substance already. There are likely hundreds of thousands, perhaps millions, of sites nationally that are contaminated in some way with some hazardous substance to which CERCLA would apply. And those sites are a much broader universe than the sites that are on the national priority list. NPL, okay, is the national priority list. This is the Superfund list. Okay, these are the sites that the EPA has determined are the most contaminated, the most important to address, that cause the biggest risk of endangerment to public health and environment. In 2018, according to the book, there were more than 1,340 of those sites nationally. Okay? So when somebody says that something's a Superfund site or a national priority list site, this is a subset of all contaminated sites, and they're ones that have been specifically picked by the EPA for more attention or, are more significant in some way. So what happens if you have a contaminated site? So a site is contaminated with hazardous substance. So again, site or facility contaminated with hazardous substance. Well, that one possible response is what's called removal, and that is a more immediate containment and removal of things that are probably doing some really bad stuff to the environment or the human health right away. So again, this is things like you have a train wreck and you've got bad stuff spilling out into onto the tracks and into the environment and into the air in Bullitt County, and you got the people in their hazmat suits coming in to address that. That's going to be removal. Remediation is really what we generally mean by cleanup, by a longer term plan and it might involve removing the stuff, okay, taking it out of the soil and disposing of it somewhere else. It might involve somehow treating maybe groundwater in a way that's going to break down the bad stuff and make it not bad. Okay, right? So there's various things that can be done there. Okay, it might involve pumping out some of the groundwater and replacing it with clean water or that kind of thing. One of the common remediation techniques now is you leave it in place and you cover it over in a way that is presumably going to prevent human contact. Okay. So for those of you who went down to the waterfront park, right? Okay, so that's exactly what happened with Waterfront Park, right? They told us about that. They said it was going to be far worse to take it away somewhere, and then they're going to be liable under CERCLA for if there was contamination at whatever disposal site. So instead, they brought a bunch of dirt in, covered over, and then planted over, paved over, right? Everybody remember that? Yeah? Okay. So, and so that works, but we also have situations where, that's supposedly what happens, and there is an elementary school built on that site, and lo and behold, it's not staying contained, and the kiddos are being exposed to some sort of contamination in what has turned out to basically be a failed remediation. Okay, so that happens. I mean, you see that in the news, and it's not good. So the question is, what is the remediation, and is it adequate, and so forth. Any CERCLA response has to meet the National Contingency Plan requirements, NCP requirements, and this is just, it's terminology that gets used. So again, if you're talking to clients, you have to have a National Contingency Plan. And so this includes remedial investigations and feasibility studies, which we call RIFS, public consultation, so you're supposed to have participatory processes that allow the public to engage with it, to comment on the proposed cleanup, the proposed plan. This is something that EJ groups very much want to do. Again, they find sometimes real barriers to effective participation. They find, sometimes it's very technical. Sometimes the participatory processes aren't very inclusive. There are times that don't work for them, or that they, don't have access to, and so forth. But that is part of what's supposed to happen, is that the public is engaged. There is a cleanup plan that is subject to, and it's usually both EPA approval and state approval. So this is oftentimes where the state government definitely is involved in reviewing and making recommendations about this. The cleanup standards are what are called ARRs, applicable, relevant, and appropriate requirements. This is where we get the cleanup standards, ARRs. Okay. as the book pointed out, ARARs come from a variety of things. They come from, in part, EPA regulations, but they also come in part from a whole variety of environmental statutes. Okay, so if groundwater is relevant, you might find that certain kinds of groundwater regulations are used to determine what kind of cleanup has to happen. There is a lot of bargaining, negotiating, jockeying back and forth, disagreement about cleanup standards. What are going to be the ARARs? Is this really going to achieve? Is this remediation plan really going to achieve the ARARs? Right. So just think again about the covering over all those contaminants and building an elementary school on top of it, right? That might be totally different than if we were building a parking garage, right? In terms of human exposure, et cetera, right? And so that ends up being the kinds of questions that get raised there. And as you see in the book, there's a whole discussion of how clean is clean. And this is something that EJ communities care a lot about. EJ communities are especially concerned that a lot of times for them, for the CERCLA facilities in their neighborhoods, that the ARARs are very lax, that the cleanup standards are very lax if you compare them to the cleanup standards elsewhere. Right? So, if, for example, and I really don't know what they are, but you can imagine that the cleanup standards for building the Cardinal Stadium, our football stadium, is built on a brownfield, right? Everybody, do you guys know that? You didn't know that? No, it was a CERCLA site, where the football stadium is for the U of L, okay? And it wouldn't be used for anything else, right? Because it was sort of sitting there contaminated. But you can imagine that maybe the university pays a whole lot more attention to that than in a whole row of industrial facilities in West Louisville. Maybe regulators are being more lax, more permissive with the cleanup standards there, and so that's a concern. The thing that everybody should take away from this, though, is if CERCLA liability applies, we're talking about very substantial cost of cleanup, often in the millions of dollars, sometimes tens of millions, sometimes hundreds of millions of dollars for these cleanups. They are very costly, and the process itself is also very costly. So how does this work? Well, first of all, there are EPA cleanup and cost recovery actions against. So look, one possibility is the EPA cleans it up itself and then brings what's called a cost recovery action against PRPs. PRPs are potentially responsible parties. You'll see that in the next slide. Another possibility is that the EPA orders the PRPs to engage in cleanup at their own cost. Okay? This is challenging for PRPs because no pre-enforcement legal challenges are allowed. You cannot, so you can bring a suit, but if you are not cleaning up while your lawsuit is pending and you lose your lawsuit, you are paying treble damages plus fines for every day that you didn't do the cleanup because when the EPA had ordered you to do so. So, you can imagine the regulated community doesn't like this at all. But if you do win your lawsuit, so if you do the cleanup at your cost and you bring a lawsuit against the EPA for an arbitrary and capricious cleanup order, right? And you're going to cite which statute? Obviously CERCLA, but you're also going to cite which other statute? The APA, right? The APA, right? Okay, so Administrative Procedure Act would be the judicial standard of review. Was their cleanup order arbitrary and capricious? And if the court says yes, you can recover your costs from the EPA. The other thing is PRPs can voluntarily clean up themselves, right? And choose to undertake this. Where some PRPs clean up or pay for cleanup themselves and then want other PRPs to pay their share, they bring what are called contribution actions. So cost recovery actions and contribution actions are they're both in the statute, but they're two different kinds of things. And there's a whole Supreme Court case that differentiated all this, which seemed actually obvious if you paid attention to what the statute says, but nonetheless, people got confused about this a lot. So contributions are where PRPs are suing other PRPs. The federal and state governments and sometimes local communities can seek natural resource damages. Okay, and so that's a specific provision in the statute that allows recovery of, allows the plaintiffs, the government or the community to get money from the PRPs for the damages they cause to natural resources. And I'm going to try to get a little bit further on this before we have to end. But I just want to tell you, just from practice, one of the the practical issues is if your client is a PRP in a cleanup action, right? You have to be very proactive about protecting your client's interest. Otherwise, you're going to be stuck with a really big bill for things that are not really your client's fault, or not really that are disproportionate to your client's contribution. In addition, there are some opportunities. And I'm going to flag that, and I'm going to show you in just a second what one of the opportunities is. So, who are potentially responsible parties? They are current owners and operators of a facility, regardless of fault. They are prior owners and operators of a facility at any time that the hazardous substance was disposed there and or in the process of contaminating the site. Again, without fault. Any generators that arrange for the disposal or treatment of the hazardous substance that ended up there. And transporters, but only if they played a substantial role in the selection of the facility. So what you get is strict, joint and several retroactive liability for response costs. What does that mean? Strict means without regard to fault. Joint and several means each and every PRP is liable for the entire amount. So obviously the bankrupt PRPs, the PRPs that are no longer in existence, Bad Chemical Corporation that went bankrupt in 1962, you're not going to get anything out of them. They're gone, right? And so forth. And retroactive means you're paying for things that happened in the past, not just what you're doing going forward. It does not depend on negligence, intent, or harm. There are defenses, acts of God, war, or third parties. Okay, don't get carried away with this. These almost never apply because even if, say, hey, a hurricane was responsible for this, they're going to say yes, but the hurricane wouldn't have led to this contamination if you weren't storing your hazardous substances in these drums outside, where in a place where hurricanes come and happen. So don't be carried away with that. There's an issue about divisibility. If you can really truly divide up, this party caused this amount of pollution over here, that party caused that amount over here. Small contributors, de minimis and de micromis settlements are allowed under the statute. These are some things that have been added. So if you're a small contributor, you can get by with, you still have to pay, but you can get by with these very small contributions to the cleanup. and municipal solid waste. If you're generating a small amount of contribution, you can get an exemption there. Lenders whose only interest in the property is holding a security interest, but lenders have gotten themselves in trouble because once they get involved in directing any decisions regarding the site and how it's operated, they lose that exemption, okay? So that's something, again, that the environmental lawyers have to advise lenders about. And then finally is the innocent landowner or purchaser defense, okay? We will pick up with the innocent landowner and purchaser defense, finish this, and then there's only one more slide that talks about the EJ issues surrounding brownfields, which we will do all that on Monday, and then keep moving forward with the EJ reading.